Datuk Seri Anwar Ibrahim's case, there were some attempts at reviewing the federal court decision, but we're not in a position to say anything about that yet. I mean, of course, this is the final decision by the apex court of the country. So I think our duty is obviously to respect that decision and be bound by that decision. And as far as that decision is concerned, it puts an end to the factual and legal disputes that have been fought for the last 7 years in the High Court, in the Court of Appeal, and now in the Federal Court. So I suppose that really puts an end to the matter.
Yeah. Could you just apply for review?
Well, it's not. We are not in a position to do that because we've only heard brief grounds of judgment being read and portions of it. So, as a matter of impression, what we got from the federal court today was basically that the federal court disagreed with the entire basis or grounds of the decision of the Court of Appeal and restored fully the decision of the grounds of the decisions of the High Court. Why or on what basis the federal court has come to that conclusion, I am not in a position to really say until I have my hands on the full grounds of judgment. But as a matter of just a general impression from what the federal court said, and I say this with a very strong qualification that it is subject, of course, to reading the grounds of judgment. I'm saying it only as a matter of impression. It appears that the federal court talked about, say for example, if we took the example of the Section 27 information given by the two respondents up on the hill in Puncak Alam, that was considered by the federal court to be a very significant factor that points towards the guilt of the appellants, of the respondents. If we took that as an example, the High Court, in the High Court trial, rejected the Section 27 information with respect to the second respondent. Never made a finding that the second respondent actually pointed the way, and in fact made a finding that the police had prior information from the information supplied by the first respondent. So to say that the High Court actually made that finding on the Section 27 against the second respondent, that they also independently let the police and gave information as to the whereabouts or the location of the crime scene, would appear, and I say this again with a qualification, to be incorrect. But of course I have not seen the grounds of judgment, and it's very difficult to say. The second thing as a matter of impression that I got was that the federal court seems to have assumed that the blood that was found on the slippers in the second respondent's car, which was the subject of very strenuous and vehement challenge in both courts, the Court of Appeal and the High Court and in the Federal Court, it seems to have assumed that the blood belonged to Altantuya. Now again, I must qualify myself because I have not read the grounds of judgment, but as a matter of impression, if that is what the Federal Court is saying, then that would be completely untrue because even the prosecution in their submission said and conceded that the blood merely was indicative of a group of people from the same maternal lineage. That means they come from the same mother. We don't know how many generations, and it was not established scientifically at trial, and the Court of Appeal was very satisfied that it was not established at trial, that it pinpointed to any particular individual. So there was a problem with the scientific evidence with respect to whom the blood on the slippers belonged. But it appears that the Federal Court had assumed that it was, or was satisfied that the blood belonged to Altantuya. Now that, if it was made in that fashion, and I say this with the qualification, it would be not a correct position as far as the evidence and the scientific evidence is concerned. So I can't say beyond that. And I must say that the Federal Court did say just now, Justice Tan Sri Suryadi did say that this was very brief grounds, and we must look at the four corners of the judgment very carefully before we make any further statements about the matter. So whatever I'm saying now is a matter of impression that I got. And yes.
To conclude what you say in
Yes.
The matter of impression, do you think that fairness, justice has been done on your client?
Well, of course, when you say whether justice has been done or not, you are asking me really the question whether I agree with the Federal Court's decision.
Just raise up 2 points.
Yes, well, okay. Like supposing the 2 points that I raised as an example is borne out when we read the grounds of judgment of the federal court, then we will have to consider what other avenues may be open to us at that point in time.
Okay, if what your early allegation is true, do you think that the court make a decision bound to the pressure of the public, rather than?
Oh no, I'm quite certain the federal court did not make this decision, with respect to any pressure from anybody. I mean,
Professionally done?
well, I mean, there is no basis to make that assumption whatsoever. And I think it's a dangerous thing to say without any evidence that the court is not independent in any way whatsoever. Of course, we have got to assume, and we must say, that the court is absolutely independent in coming to this conclusion and this judgment, that it is based on the laws and facts that have been argued and presented before both courts.
If what you raise, the doubt that you raise is established, what else can you do?
Well, I mean, of course, there is the possibility of a review of the decision of the federal court. But as you know, there is a very limited scope of the review of the federal court's decision.
So the precondition would be instruction from client?
Of course, we cannot act except if the instructions from client is forthcoming. I am not going to enter into any of that consideration at this point in time. I think it's very, very early and too premature for us to say anything at this point in time.
But after reading the grounds, then you would then
Yes, of
consider
course.
whether or not to file
Absolutely. I will
for
read the
review.
grounds. We will read the grounds. We will look at it very, very carefully with the spirit of respect for the decision of the federal court. But we will do and take any means at our disposal that is legally permissible from this point onwards. What those means are, I cannot at this moment say, except after having seen the judgment and the grounds of judgment of the federal court.
So there are other legal avenues.
Well, I would say there are limited legal avenues after this. I mean, there must be, in a democratic society, in an administration of justice, there must be a finality of a decision somewhere. And we have all argued that at one point or another, all lawyers, depending on which side of the divide they are, have always argued at one point or another that there must be a finality. And the finality comes by there being the final apex court that must finally decide all questions of law and fact and put everything to rest. And to keep challenging that without any sufficient basis or cause is to disrupt the finality concept in a democratic society. Otherwise, there will be no end to the matter. The matter will be challenged ad nauseum.
Before your client disappeared,
Yes.
he acted normally or any sign that he acted?
I am not in a position again to say that because I had a couple of communication with him about a week or so after the conclusion of the federal court hearing. Of course, I have no reason to believe he turned up for the hearing, and he was present. I've got absolutely no basis to say that he was acting strange or not strange. It was a very brief discussion we had about the hearing, and that's it.
You believe that he's still in the country?
I don't know. I really cannot say whether he's actually in the country or he is not. I think that's like asking me the same question as where he
Do
is.
you have any clue that why he disappeared rather than appear in court like Azilah?
Again, I would rather not speculate as to why he disappeared. When we say he disappeared, I think what we really mean is that he's not present in court today. I think that the speculation that he has actually disappeared has a lot more emotional and other implications in the phrase. I would rather not go there. I would say that he's not here present in court. It could just be simply because he did not receive the notice of the decision of the court today. We really don't know. Yes? May not be satisfactory, but unfortunately that's where we are right now. All right. Thank you very much.